two things you have got to give the accused before production in court.
My lord.
One is the inspection memo or the arrest memo.
My lord.
Second is the ground of arrest.
My lord.
Where have you given the ground of arrest prior to moving of the bail application?
My lord, may I submit one thing regarding this? I am for the private respondent, my lord. If this person got bail, then my life will be in danger, my lord. I was brutal.
I cannot do. The arrest is illegal, sir. I cannot say arrest.
Documents, my lord.
I am on law, sir. Supreme Court has said something. State has got to follow that, sir. I cannot do. I cannot do anything, sir. I have been granting time for a considerable.
Husband is aged about 59 years. My lord, he is the
My lord,
assistant.
Lordship kindly sees the case diary. Yesterday, your Lordship has been pleased to direct that the case diary be produced. Lordship kindly have a look at the case diary.
Okay, then. Case data then.
My lord.
To answer two things.
My lord.
Wait.
My lord.
Answer two things.
My lord.
Memo of arrest you handed over.
My lord.
Huh?
My lord.
Before production of the accused, did you hand over the grounds of arrest?
My lord. Grounds of arrest hand over. Checklist. Kon koto pata. My lord, kindly sees page 26.
26.
My lord, may I? My lord.
Is the FIR? No.
My lord.
Oh.
Case diary.
Sir, this is your checklist.
My lord, that is my.
Sir, Supreme Court has decided two things you have got to give the accused before production in court.
My lord.
One is the inspection memo or the arrest memo.
My lord.
Second is the ground of arrest.
My lord.
Where have you given the ground of arrest prior to moving of the bail application?
My lord. একবার দিন
তো এটা দিয়ে দিন আবার।
ground of arrest. My lord, subject to correction, my lord, preventing the accused from committing any further offense.
That is a reasons for arrest, not a ground for arrest. Where is Mr. Bandyopadhyay? কোথায় গেল? Sir, I am telling the Advocate General regularly that Delhi has already says arrest communication rules. There are two judgments of the Honorable Supreme Court, Prabir Purkasto and Vihan Kumar's judgment. I'm granting interim bail. I'm granting interim release, not bail, considering that the arrest is illegal.
My lord, may I submit one thing regarding this? I am for the private respondent, my lord. If this person got bail, then my life will be in danger, my lord. I was brutal.
I cannot do. The arrest is illegal, sir. I cannot say arrest.
Documents, my lord.
I am on law, sir. Supreme Court has said something. State has got to follow that, sir. I cannot do. I cannot do anything, sir. I have been granting time for a considerable.
I will face some yes, my lord. If this person granted bail.
Mr. I'm giving you the two judgments. Come at 4:30. I'll pass the order. কোথাও করছে না পুলিশ কিন্তু আমি বলে দিচ্ছি I was just holding that because of this for a considerable more than 1.5 months I'm holding this. These judgments are one is of 2024, another is of 2025. I have.
There is a judgment of 1964.
So you go through these judgments. Come at 4:30. If you have not handed over the grounds of arrest, a distinction has been made between reasons of arrest and grounds of arrest. You understand? So what is expected is that the accused is going to move a bail application. Now, when an accused is going to move a bail application,
What are the grounds of arrest?
What are the grounds? Why do you require in every case the custody of the person? That has to be handed over to the accused. That's the extension is from preventive detention. Article 22(5) has been extended to bail. You understand? That is not being done by the state. So there is a escape route also there for the state. You understand? But as a court, I have got to declare the arrest as illegal, sir, if you are unable to show. Come at 4:30, go through the judgments.
May I submit one thing, my lord. If this person release, my lord, my life will be in danger, my lord. I was several times.
Also another thing, my lord, this checklist subject to lordship's confirmation is an afterthought one because page number 25 of my brief.
I'm not bothered about. I'm not bothered. Checklist I'll consider later on. First, let the state face one thing, then the state will move, sir. Otherwise, state is not moving. 1.5 months I've been asking that Delhi has already prepared arrest communication rules. There's nothing you can take a reference from Delhi and prepare that arrest communication rules. A culture is to be developed in the state, sir.
হ্যাঁ এই বিষয়ে আলোচনা করেছিল আগে
লিভ ম্যাটার কালকে
কিচ্ছু নয়, ফরওয়ার্ডিং লেটারটায় না ওটা সই করিয়ে নিলেই হয়ে যায় প্রথমে। ফরওয়ার্ডিং ডে 10:30টায় তৈরি করে বেলমুভ তো 2টোর সময় হয় সব কোর্টে, ওটাকে সই করিয়ে নিলেই হয়ে যায়। কোনো পুলিশ করছে না এটা। ইন্সপেকশন মেমোটা কাউকে ধরিয়ে দিচ্ছে বাড়ির লোকেদের, দে থিঙ্ক দেয়ার ডিউটি ইজ ওভার। This is the difficulty. So inspection memo, reasons of arrest. Checklist is also your reasons of arrest. But grounds of arrest has been distinguished. What could be the grounds of arrest? There is an escape route for the state also. You go through that I will not say in open court. But then I'm going to release the person as an interim measure and I'll keep the writ petition pending. Will be pending, sir. He'll be under monitor. You don't see. You cannot have like in cases where you appear for the de facto complainant. You can flood the jails like that, sir.
Kindly see what they have done with me, my lord. I have all medical documents, my lord. Due to mispractice of this police.
I'm all right. I'm keep whatever is there. Writ petition will be pending before this court. I am supposed to give a full relief, but still I am giving a chance to the state of West Bengal, not to you, state of West Bengal only. There's one escape route you'll get in the grounds also. But for the time being, since you don't have any documents to show that you have given handed over the grounds of arrest to the accused, you have not. Ask your officer again.
my lord, I understand.
দিয়েছে না দেয়নি
It's 26 যেটা যেটা যেটা
That has been annexed.
একটি জজ সাহেব বলছেন this is raising this is not the grounds of preventing the accused from committing
এটা আমি দেখে নিচ্ছি।
Actually, the breeds, lucky, several things, my lord.
এইটা শুধু এইটা
I was hospitalized for 3 days.
এটা তো লিভ ম্যাটার নয় এই ভদ্রমহিলা তো কালকে এসে দাঁড়িয়ে ছিল না পিছনে কালকে
Leave
ভদ্রমহিলা
matter.
দাঁড়িয়ে ছিল তো পিছনে
Don't waste time, Mr. Bandyopadhyay. Go through the judgments. If you have any submissions, you make.
I'll make
Otherwise, I think because Advocate General is overburdened, not possible for him. I understand to complicate with the administration. I want an answer. There's an escape route also, but for the time being, I have got to give some relief.
I'll go through
Come at 4:30, huh?
it before the leave matter
Before the leave matters, I'll say. আজ 3:30
My
আছে
lord.
কে আছে ও তো আরজি করা আছে, কিছু করতে পারবো না। I can't shift that matter. You understand? 3:30 আরজি করা
3:30 matter I am appearing in that matter
আছে।
so I will be in your lordship's court from 3:30
So my lord,
So once after the RG Kar matter is
My
over,
lord,
then
my
it's
lord,
small,
my lord,
not
my
a big hearing
my lord.
today. I was not mentally prepared for taking up that matter anyhow. With the determination continuing, I have got to take up.
Right.
Chalo, Jai. Please come back. You have gone through the judgment.
I've gone to the judgment, my lord, what has fallen from your lordship, my lord, I really cannot add to it. But my lord, if I may point out a few things
Yes.
which has come to which I felt, my lord, it might not have slipped your lordship's attention, my lord. But my lord, I'm reading, my lord, from paragraph 18 of my lord, Bihan Kumar. That if the police want to use communication of the grounds of arrest motive based on the diary entry, it is necessary to incorporate those grounds of arrest in the diary entry or any other document. So it can be a verbal communication as well.
No.
If it is verbal, then it must be recorded in the diary
Yes.
with the grounds. Not only that the ground has been communicated to him. So the ground must be there because the intention of the Honorable Supreme Court is that you cannot bring the grounds later. It cannot be an afterthought.
Whatever it is. But do you have anything to show right now?
But in this matter, only this checklist is there.
The checklist is of compliance of 41(1)(a), basically. This is culture.
But I am not on fact. I am not on fact.
You have a remedy. You have seen that definitely.
Yes. But he also has a remedy. That is more important. So if your lordship, my lord, kindly take paragraph 20 and 21E. But I have ended up marking it, my lord, that when an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) has been made. The reason is that due to non-compliance, the arrest is rendered illegal. This is in 20. Then 21E, that when an arrested person is produced before the judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with 22(1) and other mandatory safeguards have been made. Therefore, they have to raise this point at the when the remand order is being made, not before the court. This
And finally, in read court, release the, you see final order of that read petition.
in that matter.
Mhm.
Final order in that, my lord.
Uh-huh.
But that I can distinguish on fact. That's a different thing. But my lord, his remedy is before the magistrate. That is what I'm trying to point out. But the intention, my lord, in this, it says that the violation of 22 as well as violation of 21. By violation of 21, anything and everything can be brought in before your lordship, my lord, on that ground. But when specifically, kindly see these two paragraphs, 20 and 21E.
Answer lies in page number 25, none appears because of the profile of the de facto complainant's daughter.
No, that's on facts. I'm not on fact. I'm on the remedy.
Such a manner that sufficient knowledge is important, communicated aid to the arrested person effectively in the language which he understands. The communication must be is such that the objection.
Then 21E.
This is which court?
Barakpur court, my lord, the order shows seen the forwarding report, arrest memo, medical slip, that's it. No ground of arrest, no checklist.
So arrest in writing is not only to the arrest.
The de facto complainant's daughter is a practicing advocate of Barakpur
He
court.
just
For her,
my lord, passed in the year
For her,
2020.
my lord, for there is an unwritten resolution not to appear for this purpose.
Regarding the applicant is
And proceeding is going on back.
correct with the trial court solely. The arrest of the offense appeal is allowed and because
I passed in the year 2023, just a junior advocate. And comment another.
therefore the applicant should be proceeded. He could have, but then the read court is not precluded also, I believe, sir. Is this court precluded?
Well, your lordship is having plenary power. Your lordship's power is absolutely wide. I don't want to argue on that point. Your lordship has power to interfere if your lordship finds that there is injustice. But I am not on that. His first remedy
Remedy was before the magistrate.
specifically mentioned in that judgment where he is relying upon. I have seen.
He has not relied upon.
I am relying upon this.
I have, this is my,
As far as the other one is concerned, that is also 27, 28 is quoted there. That deals with whether it should be an oral communication or written communication.
but Justice Koteshwar Singh's observation over here must be a written communication.
But
You have concentrated on the first
paragraph
judge.
18, if your lordship sees paragraph 18, it says that it can be a verbal communication. But if it is a verbal communication, if I appearing for the agency, I say that I have communicated verbally, the onus is upon me to prove that I have communicated verbally. The onus is not on him or any person arrested. That is what the judgment says. If that be so, it is my duty that onus has to be discharged. I can discharge my onus from the case diary. Now, what it observes in paragraph 18 is that merely if I place a case diary, that is not enough. The case diary must show the grounds why I understand, my lord, so that I cannot bring in those grounds on a next day.
Actually, preventive detention has been incorporated in bail. Earlier, this was in
Yes.
preventive detention cases.
And now, whether I am detaining or I am arresting, the grounds must be communicated, either in oral or in writing. Now, my lord, let them make my submission, my lord, is that, my lord, let them exhaust their remedy. Your lordship may keep it pending, my lord. Let them approach again.
Why should, sir? I'm asking them to furnish the bond. You have a remedy. Have you seen that?
My lord.
Huh? You have a remedy. You have seen that. Where is? So if you have that, you exercise that. If you require that.
Very good.
Your lordship. Your lordship would also see.
Oh, she's 69.
My lord, this is the judgment, my lord, I was talking about. My lord, this is Madhulimai, paragraph number 9 to 12, specifically on this point. Similar thing has happened. My lord, kindly see 9 to 12.
If
As per my instruction today, there is a date of production, my lord.
19
They have filed a bail application before the
তো ওইটাতে রিলিজ করে দিতে বলছে 1969 was before the 1973 code. Thereafter DK Basu came in. From 96 97 onwards there's a series of changes incorporated. The rights which were early, these were in respect of detention. Modhulibai case is on detention, not on arrest. The preventive detention concept has been incorporated in arrest now. So I'd been requesting the state to frame out the rules for that.
But one of the other matter is pending for the direction to be passed.
That is a POXO matter. I didn't there. That's why I've kept it like that. This is a matter where it can be applied.
And this judgment relates to Article 22 subclause 1. Well, whether 1973 code or 1898 code, well, whatever it
You were not detained, you were arrested, sir.
arrested.
The detention concept has been incorporated in arrest. That was not there earlier.
There is
Your production is there.
My lord, as
So
per
the
my-
Huh?
there is a date of production, my lord.
আমাদের ইনস্ট্রাকশনটা কি?
I am being
Instruction
fully
দিয়ে
secure,
I-
not
I-
that
আইও
instruction I
এটা
got,
বলছে প্রোডাকশন
but my lord,
আমি থাকবো
Today they have filed a bail
they have-
petition as per my.
at least I am in custody and the order taken-
Production order is when?
my lord,
Production order is
My lord, today,
my lord,
today
there
is
is
date of production,
there is
my lord.
a
And they have
production
filed a bail
on
application.
instruction I am submitting this,
Where-
no bail application has been filed. But nobody is moving.
No, my lord, today they have filed a bail application, they are moving, my lord. And I am a practicing advocate of another court, my lord.
I'm not bothered about that, sir. We are on a separate issue totally.
Yes.
We are on a separate issue.
No, I am also not going to the factual aspect.
We are on a completely separate issue totally, sir. We are not on the issue whether somebody is a lawyer, somebody has been injured, whether his merits in the case of the state. That also I have not gone into.
Only prayer, kindly peruse page number 25. That's it. Your lordship would see.
Mr. Bandyopadhyay, I am releasing, I am disposing of this matter and I am giving you the liberty to exhaust the other
Are the remedies available to me?
within the judgment itself.